Thank you, Mr. President. I rise to join in supporting this motion. And I entirely endorse the comments of my colleague, the Honourable Sarah Mitchell. This is, at one level, about whether or not Standing Order 52s are being complied with, whether information is being provided in a timely and appropriate fashion by this government to the opposition and the crossbench. But that really goes to the heart of the way government is conducted, especially government in what we hope is an open liberal democracy, government in a Westminster tradition where the executive is and must be accountable to the people through the Houses of Parliament. And any time that there is an attempt to restrict or ration or moderate or control the provision of appropriate information or compliance with an order of this House by the executive government, it is damaging to our system of government. And I recognise entirely that open government has a cost. It has a cost in terms of personnel, in time, in finding information. But a lack of open government has an even greater cost to our whole society and to our whole system. So this really is a very important motion, and I thank the honourable member for bringing it to the attention of the House. And it is not simply in the context of one SO52. Would that it were. There is entirely a pattern of, in fact, an egregious pattern of non-compliance, partial compliance, and often dismissive attitude to proper requests for information so that the opposition and the crossbench can fulfil their responsibilities. My colleague, the Honourable Rod Roberts, has given the example of the SO52 that sought to have information in relation to the Dural Caravan inquiry. We know from evidence that we received at that inquiry from Commissioner Webb that the police had done their part. They had provided that information in a timely fashion to the government, but it was not received till after the hearing, which frankly is not only disrespectful, not only not in compliance with the return date of the SO52, but also wastes everybody's time. Because the outcome of that is we may well have needed another hearing day, which would have been the police coming back again and wasting their time. Total misallocation of resources because for whatever reason, the government chose to hang on to that information past the return date rather than actually comply, not with a note from Mr Roberts, please would you mind if I had this, but an order passed by this House, a motion which has been passed by the Legislative Council requiring the government to comply. And the dismissive approach to what are orders of the Legislative Council by this government is astounding, because it is very much as if the executive is putting themselves right above this elected parliament. And that pattern has significant consequences for the maintenance of democracy in our society. Another example is an SO52 order that was recently made on my motion with respect to information in relation to the community justice centres. So that was, the date for return of that was yesterday, 28th of May. On the 26th of May, a letter was drafted, which I received on the 27th of May, the day before the order was due, seeking a 4-week extension, the day before it was due, and a reduction in the number of documents to be provided. Now, presumably, this would have been apparent that there were problems with this well before the due date. Why the day before? That is disrespectful, that is arrogant, and it should not be happening. And interestingly, the letter that I received attached correspondence from Mr Carl, the Acting Director of Open Government, advising that, quote, the department is prepared to provide Ms Carter with details of the number of representations received and a redacted version of a reply by way of informal release under Section 8 of the GIPA Act. So kind of the department to decide the way in which they would comply with an order of this House, the way in which they would comply with a decision of this parliament. And I am sure that this attitude being expressed by the executive, as one says, the fish rots from the head. And this is why this motion is being brought, because of these constant examples. And sadly, the arrogant approach to the provision of information is not restricted to SO52s. When I was a child, I used to quite enjoy Ring-a-Ring-a-Rosie. I don't enjoy doing Ring-a-Ring-a-Rosie quans, which has become all too familiar. I asked the Minister for Housing questions in relation to the shared equity scheme. And the reply I got back was, ask the Treasurer. I asked the Treasurer questions, the same questions, in relation to the shared equity housing scheme. And the answer I got back, ask the Minister for Finance. And I asked the Minister for Finance the same questions in relation to that scheme. And I got back nothing. No serious attempt to provide information. I got an answer to the question at question time today. So the information existed, it could have been provided, but for whatever reason, there was a decision not to. Now look, it is annoying, it is frustrating, it wastes time, but it is also damaging in terms of the system of government. The allegation is often thrown around that this side of the House is Trumpian. Now, I'm not exactly sure what that means, but the best I can work out, it seems to mean that the executive is so removed from the legislature or so arrogant about their position vis-a-vis the legislature, or not feeling they have any responsibility to the legislature, to behave in a particularly high-handed authoritarian executive way. Can I say, if anybody is behaving in a Trumpian manner, it is not this side of the House. It is the government.